Welcome to Part 4 of the Custody Actions in Bedford County presentation. Part 4 will discuss how to file a custody action. You will learn how to complete the custody complaint and other legal documents. So now that you've decided where you can file and that you're a party who can file, the next step is to complete the legal documents or pleadings, specifically the complaint for custody, the order of court, and the criminal history and abuse verification. These documents are available in the Prothonotari's office or on the county website. Once these documents are complete, you will file these documents with the Prothonotari's office. There, you will either pay the filing fee or you will also file the informal paupers petition as we discussed in Part 2. You will receive a conference date from the court. You will have to serve all of the paperwork, all the legal documents on the defendant or your other party. We'll talk more about this in Part 5. And last, you will appear at a custody conference, which we will discuss in Part 6. Now, please have the order of court in front of you so that you can follow along and complete it as we go. The order of court provides the defendant with notice that he or she is being sued and what type of custody the plaintiff is asking for. It also provides the parties with the date of the custody conference, as well as information about the custody procedures. For instance, the custody court may issue a custody order or a warrant for the defendant's arrest if the defendant fails to appear at the conference. The defendant must file the criminal record and abuse history verification form before the conference, but not later than 30 days after service of the complaint. No party can relocate with the child unless the requirements for relocation are met. The order also provides options for legal services as well as information about the Americans with Disabilities Act. Specifically, if you need an accommodation, you must let the court know 72 hours before your court date. In the order of court, as we discussed before, this will be the same caption as you use in every pleading. Now, in this first paragraph, you will notice that there are words in blue, and those words are the directions, instructions, and explanations that I put in to make this more beneficial for you to help you in completing the form. Whereas the words in black are the actual words that are in the documents. So in that first paragraph, you will put down the defendant's name. You will check what type of custody you are looking for. And you can refer back to slides 8, 9, and 10 in Part 3 for those definitions. And then you will list the children's names. These are the children that you're asking for custody of. In that next paragraph, the court will give you the conference date, and the court will check whether this is a conciliation or mediation conference, a pretrial conference, or a hearing before the court. Your first scheduled appearance before the court will be a conciliation conference. And last, the court will sign this, and once you receive it, you will serve it with the other legal documents on the defendant. We will now discuss completing the complaint for custody. Again, if you have this document, please have it with you now so that you can follow along. Now, as you go through this complaint, this form is appropriate when there is one plaintiff and one defendant, and when there is custody of one child sought, or where custody of several children is sought, but the information in questions 3 through 7 are identical for the children. If there are multiple parties, then you will have to adapt this complaint to accommodate all the parties. For instance, if a grandparent is filing for custody against the mother and father, there would be 2 defendants. Where there's custody of several children and the information is not identical, the complaint will contain a separate paragraph for each child so that you can answer specific to that child. So number one, the plaintiff, that is the person who is filing, and you will put down where the plaintiff resides, so your address, unless your address is confidential. And when we say your address, that means your street address, the town, the state, the county, right? And in number two, the defendant, you put the other party's name here and where that person is residing. In number three, you again will check what type of custody you are looking for. And you can refer back to slides 8, 9, and 10 in part 3 for those definitions. You will then list the names of the children, their present residence, so where are they living, the street, the state, the county, and their age and date of birth. Again, these are the children that you are asking for custody of. Also in number 3, you will check whether or not the child was born out of wedlock. So, were the mother and father married when the child or children were born? If they were married, then no, the child was not born out of wedlock. You will now put down who the child is living with and where the child is residing. During the past 5 years, you will list where the child has resided during that time, who the child has lived with, at what address, and when. In this question, the court wants to know about the parents. So the parent of the child is. If you are one of the parents, you'll put your name down here. If you are in loco parentis status, or a grandparent or a great-grandparent, then you need to put down the name of the child's mother or father. You will also put down the address of the person who was just named. And then you will check the description that applies to the parent, whether they are married, divorced, or single. And then the next question, again, the parent of the child. So if you're a parent of the child, then you put down the other parent in this question. If you are in loco parentis status or a grandparent or great-grandparent, then you put down the name of the child's mother or father, whichever person you did not just list above, and where they're residing. Again, you put down whether this parent is married, divorced, or single. Number 4 is now asking about your relationship with the child as the person who is filing this complaint. So the relationship of the person who's filing to the child. And that could be mother, father, grandmother, grandfather, etc. And you will put down who you reside with and what your relationship is to that person that you reside with. Now you will put down the relationship of the defendant. That is the other party, the party you're filing against. What is their relationship to the child? And then you will put down who that person lives with and what their relationship is to that person. Here you will check whether or not you have participated as a party or a witness or in another capacity in any other litigation concerning the custody of the child that you're filing for custody of in this court or another court. So you want to put down whether you've been involved in any other case involving this child. How were you involved? and also put down the court information about this case, including what happened. For example, have you ever filed a protection from abuse action where you were given temporary custody of the child? If so, make sure to put down the court that this PFA was in, the term, and the number. The next question asks whether the plaintiff has or does not have any information of a custody proceeding concerning this child in a court in this Commonwealth or in another state. So if anyone has ever filed for custody for this child, either in this state or another state, you need to put that down. Put down the court information and what happened with that case. Next, you will put down whether you know or you do not know of a person not a party to this proceeding who has physical custody of the child or claims to have custodial rights. So do you know of anyone else other than mother or father who believes that they have a right to custody of the child that you are asking for custody of? If so, you need to give that person's name and their address. So, for example, a grandparent may have custodial rights if the child has lived with that grandparent for over 12 months, in which case you will put down that person's information. Now the court is asking why you should be given the type of relief, type of custody you're asking for. So the best interest and permanent welfare of the child will be served by granting the relief requested, because here you will give facts showing that the type of custody you're asking for is what is in the best interest of the child. So if you are asking for primary physical custody of the child, why is that in your child's best interest? Is that what the current arrangement is? How long has that been the arrangement? You will give all those reasons as to why you feel that this is best for your child. And in number 8, you'll put down each person whose parental rights to the child have not been terminated, and the person who has physical custody of the child have been named as parties to this action. All other parties named below who are known to have or claim a right to custody of the child will be given notice of the pendency of this action and the right to intervene. So if mom and dad still have their parental rights, they're already named in this action. If they no longer have their parental rights, as in this child has been adopted, then the biological mother and father will not be put down. This is to make sure that anyone who has any rights to this child knows about this proceeding. In number 9, this deals specifically with grandparents filing for custody. In 9A, it states that if the plaintiff is a grandparent who is not in loco parentis to the child and is seeking physical and or legal custody, you must plead facts establishing that you have standing. So standing is a party's right to make a legal claim or ask that a duty or right be enforced. You must explain how you meet these requirements. And you can refer back to slide 11 in part 3. But for grandparents in 9A, this is asking you, did the relationship with the child begin by parental consent or court order? Did you assume or are you willing to assume responsibility for the child? And which of these conditions is met? That the child is dependent, the child is substantially at risk due to parental abuse, neglect, drugs or alcohol abuse, or incapacity, or the child resided with the grandparent for at least 12 consecutive months and was removed by the parents. For 9B, if the plaintiff is a grandparent or great-grandparent who is seeking partial physical custody or supervised physical custody, then you must plead facts establishing that you have standing. Again, you could refer back to slide 12 in part 3. This is asking Is the parent of the child deceased? Or have the parents started divorce proceedings? Or has the child resided with the grandparents or the great-grandparents for at least 12 consecutive months and was removed by the parents? If so, you must put that within this petition. Now, 9C talks about a person who has the status of in loco parentis. If the person is a person seeking physical and or legal custody, as a person who stands in loco parentis to the child, you must plead facts establishing standing. So here, you must explain how you meet those requirements to file for custody of this child. Remember, we talked about a person who stands in loco parentis to the child is a person who is acting as a guardian or caretaker of the child. They've taken on all or some of the responsibilities of the parent. You will have to show how you are in loco parentis to the child. How did you become involved in the child's life? Did the parent make you a part of the child's life? What parental duties have you assumed? What is it that you do for the child? These are the kind of questions that you'll have to answer and explain in 9C. And 10 states that you have attached the criminal record and abuse history verification form, and we'll discuss that more in the next slide. The next paragraph says, wherefore the plaintiff requests the court grant. Here again, you'll check the type of custody that you are asking for. This is the same custody that you listed in the beginning of the complaint in paragraph 3, slide 6. And then you will state that you verify that these statements made in this complaint are true and correct. You understand that the false statements are subject to the penalties of the criminal statute relating to unsworn falsification to authorities. And we will talk about the verification in more detail in another slide. For the criminal record and abuse history verification form, again, please have this in front of you so that you can follow along. Both parties must file this verification, and the plaintiff, the party filing, must provide a blank form for the other party, the defendant, to complete and file with the prothonotary. The court will look at this form and will determine whether there is the existence of a criminal or abuse history of either party or a party's household member, and whether they pose a threat to the child or whether further evaluation or counseling is necessary. So in this verification, first, you will put your name at the beginning. You will check whether you or a household member have been convicted, pled guilty, or no contest to the listed crime, or whether there are pending charges to that crime, and you will give the date and the sentence. There are numerous pages of crimes. Make sure that you go through each of those completely. On page 4, you will check whether Children and Youth Services or a similar agency has been involved with you or a member of your household. You will state when that involvement occurred and what happened. Was there a finding of abuse? Was it unfounded? And you will also check whether you or a member of your household has been involved in abusive conduct as defined in the Protection from Abuse Act or a similar statute in another state, and give that date. We'll talk about those definitions in the PFA Act on slides 23 and 24. If you or a member of your household was convicted of one of the crimes listed or found to have abused someone, then you must list any evaluation, counseling, or other treatment that you received following this conviction or finding of abuse. For example, this could mean drug and alcohol counseling, or a mental health evaluation, anger management classes, or a domestic violence intervention program. You'll also provide your household member's name, date of birth, and relationship to the child if the household member was convicted of any of the crimes on the list. You will also, in number 5, put down the criminal or abuse history of the other party or members of the other party's household. If you do not know the other party's history, you can look that up at the website pacourts.us, and you will then look under docket sheets. This is the Unified Judicial System of Pennsylvania web portal. When you click on docket sheets in the upper right hand corner, you can search in the Criminal Court of Common Pleas or the Magisterial District Court, and these would be places where you would find out, is there a case, what has occurred in this case? Was there a guilty plea? Was there a trial? Was it dismissed? You can search by the other party's name, their county, the docket type, for example, criminal docket, the status of the case, or the date of the case. The criminal record or abuse history verification asks whether you or a member of your household has been involved in abusive conduct as defined in the PFA Act or a similar statute. The Pennsylvania Protection from Abuse Act, or as I've been saying, the PFA Act, defines abuse as attempting to cause or intentionally, knowingly, or recklessly causing bodily injury, serious bodily injury, rape, or other sexual offenses as listed. Placing another in reasonable fear of imminent serious bodily injury, false imprisonment, physically or sexually abusing a minor child, or knowingly engaging in a course of conduct or repeatedly committing acts towards another person, including following the person without proper authority under circumstances which place the person in reasonable fear of bodily injury. This is also sometimes called stalking. In your IFP petition, as well as the complaint for custody and the criminal record and abuse history verification, you must sign the verification that what you have written is true. There are consequences if you put down something on one of these documents that you know is false. So specifically, if you look at subsection B, a person commits a misdemeanor of the 3rd degree if he makes a false statement, a written false statement, which he does not believe to be true, on or pursuant to a form bearing notice authorized by law to the effect that false statements made therein are punishable. So you really want to go through these legal documents that you're completing and make sure that everything you are putting in there is true. Now you have learned how to complete the complaint for custody, the order of court, which schedules the court date, and the criminal record and abuse history verification. Once you have completed these, you will file this with the prothonotary, and again, either pay the filing fee or file the petition and ask the court to allow you to proceed in forma pauperis, meaning waiving the cost. Once you file these documents, you have to let the other party know that you filed these documents. So in part 5, we will discuss how to serve the other party and how you can prove that you served the other party.